Good morning. These proceedings are held in a cause entitled Paul Henry Gingerich against the state of Indiana, an appeal from the Kosciuszko Circuit Court. The court recognizes for the appellant Ms. Foster, who has reserved 5 minutes for rebuttal. Is that correct? That's correct. And for the government, Ms. Sanchez, are you prepared to proceed? You may be heard.
Thank you, Your Honor. May it please the court. At the outset, on behalf of my client and my client's family and friends, many of whom are here today, we would like to thank the court for setting this case for oral argument. We are well aware of the court's docket and time constraints, and we very much appreciate the opportunity to be with you here this morning. At the end of the day, we know one of the parties to this appeal is going to lose. And when that day arrives, the non-prevailing party will have 30 days to prepare a petition for rehearing or transfer. That petition will be based on a constrained record. Outside evidence will not be able to be considered. The parties will be intimately familiar with the issues on that petition because they will have fully briefed the case previously. 30 days to draft a petition that may not exceed 10 pages. In short, 30 days to prepare a petition, the contents of which are extraordinarily constrained and well known to the parties. In contrast, Paul Henry Gingerich's lawyers had 5 business days to prepare for the juvenile waiver hearing in this case. This is the transcript of that hearing. It's 90 pages long. The court reporter had 3 months to type this document, a hearing that Paul's lawyers had a week to prepare for.
By contrast, is it true that in Marion County the practice is at least 90 days?
At least 90 days, Your Honor, yes. I believe that that's also true in some of the other counties that are more familiar with dealing with these kinds of cases.
Ms. Foster, when one complains about a denial of a continuance, it is typically one's responsibility to show that but for the lack of this continuance, I was precluded from doing something that I will now tell you I will do. What is it that you now know that they didn't know in those 5 days?
They didn't know that Paul Henry Gingerich was incompetent to stand trial. At the sentencing hearing, a report...
And where does the record show that unerringly he has been determined to have been incompetent?
I believe that the second report from Dr. Ross unerringly shows that. Admittedly, he does not use the word incompetent. It is our position that he doesn't use that word because he's more of an old school expert, if you will. He was of the opinion...
We have different schools of experts?
No, Your Honor, but I do believe that there are some experts who feel that it's improper to evade the position of the fact finder. At the end of the day, it was the court's obligation to determine whether Paul was competent or not competent, and this expert clearly provided information and opinions that would lead but only to one conclusion, and that was that Paul was incompetent. If there's any question about whether that's what Dr. Ross is saying, we asked for this in our brief, and we would ask again to remand for a hearing, and we will present the evidence that that is precisely what Dr. Ross was saying.
And that incompetency, it may well be that at the time that he was 12, he was incompetent.
Correct.
But isn't it imperative that if you had a remand that you have to show that he's incompetent today?
We would have to show, if we had a remand to determine whether he was competent at age 12, we would have had to show that he was competent at that time. In order to go forward, the state would have to show that he's competent today. Okay,
so your remand for showing he was incompetent at 12 years of age would be to show that it was erroneous to have him waived beyond juvenile court.
Correct.
And what's your support for your position that competency would be an issue as of the prior date as opposed to current date?
Well, clearly he would have to be, if the court were to remand for a new juvenile waiver hearing, which is what we're requesting, he would have to be competent to proceed, right, to go from that point forward. If the court were to remand for a determination as to whether he was competent when all of the proceedings occurred previously, then we would have to show that he was in fact incompetent at that point in time.
Right, but what do you base your position on? Is there case law to support your position?
Pate versus Robinson says that where a reasonable person would believe, and Pate cited in our brief, and it's an old U.S. Supreme Court case, it says that where where the record reflects and a reasonable person would have cause to believe that a question concerning competency exists, the court is under a duty to inquire further, and that duty to inquire further extends even where no other party alleges incompetence. Indeed, it extends.
That state case stands for the proposition that if I were the trial judge and I have some reason to believe that there's a competency question, notwithstanding the fact that the state nor the makes any motion, I have an obligation to move forward, right?
That is exactly correct, Your Honor.
Okay. What's the evidence here that would have told Judge Reed that he should have done that?
Paul Henry Gingerich was this tall at the time he stood in front of Judge.
Yeah, with all due respect, ma'am, height does not determine a person's competency.
With all due respect, Your Honor, I think that I certainly agree with your position, with what you just stated. However, he was very slight. He was very young. It's our position that the size of this child should have caused the court to be curious about whether he had the emotional maturity to attain competence. But there's more than that. Counsel indeed sought an opinion from Dr. Ross, and the court was aware of this rather early in the proceedings as to whether Paul was competent, because there was a preliminary report filed by Dr. Ross that said counsel has inquired as to whether his client is competent. Dr. Ross filed an initial report. He had not yet talked to Paul, just sort of documenting the state of medical research, if you will, into competence of young people. After that, there was a letter from Dr. Ross that clearly set out facts that would lead one to believe that Paul was incompetent. He didn't understand what his lawyers were talking about. He didn't understand the concept of plea bargaining. He believed that the judge's job was to convict him. There was a long litany of things in our brief that we've alleged from the second Dr. Ross report that would unerringly lead a reasonable person to believe there was a question about competence.
Okay, but Ms. Foster, let me interrupt you for just a second and assume all that's true. Okay. If Paul Gingerich if this is remanded and it goes back, Paul Gingerich will be likely 16 years of age when he goes back. And the trial court is going to determine, and I believe I heard you say that it would be the state's burden to show competency as of the present time. Is that correct?
If indeed he was determined to be incompetent previously, yes.
Okay, but but he's now 16. So all those factors that were relevant, when he was 12, are not going to be relevant this time. He is older, he is more mature, the development in immaturity no longer obtains, at least to the same degree. And so, how do we, we can't put him back, if you were right, we can't put him back where he should have been. He goes back now, and he may face a murder conviction in adult court again, extensive,
Candidly, ma'am, in preliminary conversations, and we have them, there's a concern that you might win the battle and lose the war.
Your Honor, I trust, I've been at this for 30 years. I trust this court and I trust the justice system that when people get a due process opportunity to present a fair case on behalf of a kid who's 12 years old in particular, but anyone for that matter, that the justice system does the right thing.
So you're secure enough in your position that this child would stay in adult court,
in
juvenile court?
I am absolutely secure
because
in
you
that
know
position.
that you risk the refiling of the murder charge.
I'm sorry?
You know that you risk the refiling of the murder charge.
I know that I risk that. And I also know what the evidence would look like at a fair juvenile waiver hearing, and I am very confident that we would prevail at that.
Part of the concern that you have expressed in your written materials that you've given to us is the fact that the trial judge was presented with evidence that we now know was incorrect about alternative placements. Is that right?
Yes, Your Honor, in addition to other things, but yes.
Can you enlighten us on what the trial judge didn't know that he should have known?
Yes. And if I can address that question by telling you what the court found that appears to be based on the false testimony of probation officer Babcock, and then I would like to tell you what the actual truth is. So the court found that a juvenile cannot be placed in a juvenile correctional facility after age 18. The court was concerned that left the court without a threat to further the child's rehabilitation. We know from statute, that's the court's finding. It's very similar to the false testimony presented by Officer Babcock. We know in 1113-6-4, the Department of Correction can hold a juvenile for any time that it deems appropriate up until and including age 21. At such time as the Department of Correction decides to release the child, the statutes require the Department of Correction to advise the juvenile court so that the juvenile court can, if it wants to, place the juvenile on probation until age 21. So the court Babcock's testimony was false. The court apparently relied upon it.
So he would be detained until age 18 with the possibility of probation until 21? Is that the current
No,
state?
he could be detained by the Department of Corrections until age 21 by statute.
In a secure facility?
In a secure facility.
All right, and just to maybe correct the record, is the child now 14?
The child is now 14.
And what's his birth date?
It's February. I know that he'll be 15 in February.
Okay.
Furthermore, the court found that, quote, our laws really do not afford an effective rehabilitation when a child is charged with an act of murder. It appears in the context of that statement in the court's rationale for waiving the child to adult court, that what the court was talking about is there's no secure facilities that will treat a child who's accused of murder. Babcock had testified that there, in fact, were 0 facilities in the state of Indiana who would take a child charged with homicide. He admitted Paul would be a terrific candidate for a juvenile facility, but for the fact that there were no facilities to take him.
What was the cross-examination that took place by Gingrich's counsel at that time to correct the false testimony?
Honor. There was not.
Okay. Certainly there was the opportunity.
Well, there was the opportunity in that the court did look at counsel and say, do you have any cross-examination? It would be our position that given, 5 days to prepare, I would imagine that the lawyers were pretty overwhelmed. I don't know that, but I would be overwhelmed if I were in their place.
What did cross-examination consist of?
We have no questions.
I see.
What we know is that there are, in fact, 17 locked and secure facilities in Indiana that would accept a juvenile accused of homicide. Moreover, even though the court directed that Mr. Gingerich be sent to an adult facility, when the Department of Corrections got a hold of him, they said, we can't do this. The Department of Corrections said, we can't send him to an adult facility. And in fact, sent him to a secure juvenile facility run by the state of Indiana, where he is currently being rehabilitated and doing terrifically. That is the type of evidence that if we had a fair, due process consistent, compliant hearing, we would be presenting that type of information. This court was misled.
So if we remanded back for a waiver hearing, you would rely solely on the report of Dr. Ross, is that correct, to determine competency?
No, I would not rely. I mean, I could rely solely on that, but I understand the burden that I'm up against, and I would not rely solely upon that. But I could.
Because your burden would be to prove competency when he was 12 years old.
That's correct. Interestingly, with regard to the issues that Officer Babcock falsely testified, there is nothing. You can search the state's brief from now for the next 100 years. There's nothing in the state's brief addressing that fact. Moreover, had counsel had the time, they could have presented a mental health examination. And while we contend that examination would certainly show that he was incompetent at the time, we believe that there are other aspects of a mental health examination that could aid the court, not just in the question of competence, but the question of juvenile waiver in total. And why is that? Because we would be presenting evidence regarding juvenile brain development, which is consistent it's consistent, and there's a lot of it in the medical community, that the juvenile brain, that those portions of the brain that dictate impulsivity and judgment develop last.
This is what you would have told Judge Reed had you had the opportunity.
That is correct.
Okay. So what else? Did the judge make any mistake other than believe what he was told?
Well, I can't imagine why a court would I mean, I don't understand what the rush to judgment was. I think that this case was mistake-ridden from the moment it hit the juvenile court, frankly. I don't understand why you would only give a 12-year-old. I mean, we believe that he's the youngest child ever waived to adult court in Indiana. Why would you only give 1 week? I mean, that's the first mistake.
And yet the statute allows for waiver of 10-year-olds.
Yes, it certainly allows it, but that doesn't mean that it's good judgment or that it wouldn't be an abuse of discretion in a particular case. This is a little boy who has 0 referrals to juvenile court, who, I mean, he just doesn't present the way some of the juveniles that you see in front of you present. No referrals to juvenile court, comes from a good family, does well in school. The worst they could say about him is he talked in class. I mean, didn't we all talk in class?
I bet you didn't, Ms. Foster.
You know me too well. I see that my time is up, so
Thank
if there
you,
are no further questions, thank you.
Sanchez?
May it please the court. Defendant, his 2 attorneys, and both of his parents got together with the prosecutor in this case, and they all agreed to a just resolution.
That was after they were in adult court.
Yes, sir.
Okay. And I might have a tendency to be predisposed to that statement, but you have to, my understanding is that you have to get a juvenile from juvenile court to adult court before we can have a conversation about what happened in adult court. Would you agree with that as far as a process?
Yes, Your Honor. The case did begin in juvenile court.
Okay. So one of the complaints here is that the defendant was not permitted enough time to prepare for the waiver hearing. And in fact, at the waiver hearing, there was, I guess the term would be false, misleading testimony that you haven't refuted. Let's start with rather than start where we ended up with the plea bargain, let's go back and talk about the juvenile waiver. Could we do that?
Yes, Your Honor. Just as a preliminary statement to that, I would point out that it is what happened subsequently in the adult court in the defendant's decision to waive any challenge, along with the act of pleading guilty, waiving any challenge to juvenile proceedings, that takes this discussion out of the court's decision. But I will address your...
If a person is incompetent to be sent to adult court, would it not follow that they're incompetent to give up their right to complain about being sent to adult court?
Well, first, Your Honor, we don't know that he was incompetent to...
Right, but one of the questions we're trying to pose is whether he was incompetent when he was waived or whether he should have been waived. Agreeably, those are 2 different questions. Mm-hmm. But don't we have to answer all of these before we can get legitimately to here? And if we're legitimately here, then your point is he's waived all of that, right?
Well, yes, Your Honor, but there is no reason to believe that he was not competent in the juvenile waiver proceedings. There was certainly nothing before the juvenile court to suggest that he wasn't competent at that time.
Not in those 5 business days that the case pended before the juvenile court judge.
I'm sorry, excuse me, Your Honor?
Not during the 5 days that it was still a juvenile proceeding.
It was 1 week from the probable cause to the waiver hearing, and no, there was nothing presented. And there's been nothing presented since that he was incompetent at that time.
How do you get past the amicus telling us that standard in Marion County is a minimum 90 days to prepare for a waiver hearing? Why the rush to judgment here by this juvenile court?
Well, Your Honor, the issue before this court isn't what the best practices for juvenile waiver hearings are. It may vary from case to case.
Well, we do have to determine whether or not due process has been accommodated, do we not?
Well, Your Honor, following the defendant's guilty plea, there are no issues before this court. If if he has issues to challenge his guilty plea and conviction, they belong in post-conviction proceedings. That's the path to pursue his claims here.
So it's the government's position that you will choose not to defend anything that happened in the juvenile court because of what subsequently happened in adult court.
No, Your Honor, we can defend what happened in the juvenile court. What the law says
I'm suggesting to you that you need to do that.
Okay, yes, Your Honor. What happened in the juvenile court is that defendant in this case committed murder. There was probable cause to believe that, and the law says that when someone over the age of 10 commits murder, the court should presume that the juvenile system is inadequate to the task and waive him to adult court, and that's what is in fact happened in this case.
The record before us doesn't contain a transcript of the initial juvenile hearing or the probable cause affidavit. Is having that record essential to our determination of the issues before us?
No, Your Honor, there's no dispute about the fact that probable cause existed for to believe that he committed murder, and that evidence was again subsequently represented at the waiver hearing. So the state did present the evidence that established probable cause, and that is in the record in the context of the waiver hearing itself. And no one's really disputing in this case that the murder occurred or that the law presumes that he belongs in the adult system. That's exactly what happened. He was waived to the adult system where the law presumes he belongs.
Well, that's after full investigation and hearing, which the Supreme Court says shall not be a perfunctory proceeding, which we said the waiver order must not merely recite statutory language. And yet I look at the order and all I see is the language of the statute. I look at the fact that, even though the state's brief in this case was filed 3 months and 2 weeks after, the appellant's brief, that this young man was forced to go to the waiver hearing 7 days after the probable cause determination. How can that possibly be consistent with due process?
Well, Your Honor, he received the opportunity to present evidence that he did present evidence of that hearing.
How could you get ready for a hearing? I mean, what did he present?
He presented evidence from his parents, family members, a neighbor, I believe, who knew him about, testimony about him. Whether a more cautious judge may have given him additional time, it very well may be the practice in other courts. It may even be better practice. But that's not the question that we're presenting with at this stage in the proceedings. At this stage in the proceedings, he had a valid waiver or sending him from juvenile court to adult court, and in the adult court, he made a decision, along with his 2 attorneys and with both of his parents, to plead guilty in exchange for a very substantial benefit. As this court hinted earlier, what he was giving up wasn't the right to remain in the juvenile system. It was a speculative opportunity to challenge the waiver proceedings on appeal. That only if he then succeeded would he land back in the juvenile court, still facing a presumption that he belonged in the adult court. A heavy burden to overcome to show that not only would it be in his best interest, but in the best interest of the safety and the welfare of the community, despite his heinous crime, that he stay in the juvenile system.
So he was facing a maximum 65 years in prison if waived to adult court potentially, and if he was convicted of murder, correct?
Yes, and that's what he would again face if he were to return to the juvenile court and fail to meet that very heavy burden of showing that the community is better off keeping him in the juvenile system.
And as it stands now, he's 14 years old, will be detained likely in the juvenile system until he's 21, possibly at that point released to adult court, to adult system, likely be given the opportunity to get a college degree and have time cuts. So as it stands now, this child could be totally out of the prison system by the time he's 22, potentially?
Yes, Your Honor. In fact, he's currently slated for release at 24. Of course, as you mentioned, he has educational opportunities which could further reduce that.
He's probably too young to start going to college, isn't he?
Well, he would get his GED presumably first in the juvenile system and then start working on a college degree, I presume.
Yeah.
Yes, both of which would allow him to reduce.
Explain to me how the people of the state of Indiana are greatly affected if we have a remand to determine whether or not this child was competent when he was 12. What you tell me is if he behaves well in the present system that he's in and he takes advantage of all of his opportunities, he's likely to get out of that system when he's 21 and a half or 22. Otherwise, he'll get out when he's 21.
24, 25.
Yes, Your Honor. I'm sorry, in that I think I lost your question in that.
Well, I think that what we say down in the department, what's the difference?
Well, the difference is, Your Honor, that he entered an agreement with the state to resolve this case. It was a just resolution that everyone agreed to, brought finality to this case, and Indiana Supreme Court precedent says that when you do that, one of the consequences of agreeing to what the just outcome of your case is you give up the right to challenge it on direct appeal. Now, he can bring post-conviction proceedings. It's not that he's without recourse. It's just that the path to remedies that he may be entitled to is through the post-conviction process,
And
which actually is...
Is the state confident in the ironclad nature, if you will, of the plea agreement in terms of both parents signing off, him signing off, his two lawyers signing off, and parents then also signing an addendum saying that the child understood his rights?
Yes, Your Honor. I mean, I think that is our best evidence that this was not a railroading of a juvenile or a gross injustice. This was a carefully thought out decision by defendant, again, two attorneys, both of his parents.
I think your strongest point is once you're to adult court, that's right.
Yes, sure.
You just got to convince me that it's appropriate to be in adult court. My colleague said that there's a presumption that anybody that commits homicide after they're 10 years of age should be in adult court.
Counsel said that.
Counsel said that, I get. But wasn't there a... Isn't it your concession that a probation officer told the trial judge that there was no place to put this child, and in fact, we know that there were?
Well, Your
Doesn't
Honor,
that trouble you?
it's not at all clear to me that there was
We are
false
all
testimony.
former trial judges, and it troubles us when somebody doesn't tell us what we're supposed to really, that we were going to base a decision on something that's not true.
Your Honor, it's not at all clear to me that that's false testimony. What the probation officer says was, to his knowledge, there wasn't a facility that would take Gingerich because of the murder charge. But it's not actually been shown to me that there is a facility that would accept him. All kinds of, though there may be facilities that would consider a juvenile who's committed murder, it's not clear that he would meet all of the admissions requirements to any specific facility. For instance, some facilities will only take juveniles who have developmental disabilities or issues, or certain mental health issues in addition to the delinquency issue. So I'm not sure what is the actual options. There still hasn't been shown exactly what facilities would in fact take this particular individual, and that is
But
something...
if we had lawyers that were fully prepared at the waiver hearing, the trial judge would have known those answers, wouldn't they?
Possibly, Your Honor, but again, we have to consider the fact that this judge was looking at and facing a presumption in favor of waiving this defendant to adult court. That the question before him was whether both defendant's best interest, but also the best interest of the safety and welfare of the community, and that the concerns that the judge expressed are the same regardless of what facilities are available because, the time was the primary concern to him. The fact that as a practical matter, his hands may be tied in dealing with the juvenile. But again, once we have a valid waiver, a waiver that is supported by the presumption, it's exactly what the law says should happen in this case. And once that happened, the case proceeded to the adult court where defendant gave up the opportunity to challenge the juvenile waiver proceedings any further by agreeing to a just resolution of the case. Again,
You cannot use the bootstraps to, I'm sorry, if you're not supposed to be in this room, what happens in that room is illegitimate. You have to legitimize being in that room. So you have to almost save all your words for what happened in the waiver.
well, Your Honor,
If your point is that it is presumed and there's nothing to indicate and it's her burden to overcome the presumption, she hasn't done so. She hasn't shown that the trial court, if they gave him 5 weeks, that they would have come up with something different. Isn't that your best argument?
Yes, Your Honor. And in fact, what he's essentially saying by entering the plea agreement, giving up the right to challenge that further, he's saying that I didn't meet that burden in the waiver proceeding, and tacitly saying that even if I got my second shot, I probably still wouldn't meet that burden. He's giving up the ability to challenge that because it was his burden. He did not meet it. He's not likely to, and he's better off. He's made the choice that he's better off taking the deal in the adult court, which again has him set to be released at the age of 24.
Is the issue of failure to order a competency evaluation, is that a case of first impression for us?
Well, no, Your Honor, there's precedent that if the judge has reason to believe that the defendant is incompetent, has an independent duty, even absent a request to order a competency evaluation. But there is no evidence before the court in this case that would cause that. And in fact, there was a lot of evidence before the court in this case that the defendant was in fact competent. He has the defendant, both of his attorneys and both of his parents telling the court that the defendant knows and understands what he's doing here.
So you see it as no abuse of discretion, the court's failure to order a competency evaluation?
There's no error in failing to order it because there was no reason to order it.
And
There was nothing.
is there case law to support your position that in case of a 12-year-old facing a murder charge in Indiana, that it's not an abuse of discretion to not order a competency evaluation? Do you have any case law to support your position?
I guess not, Your Honor, since there's no authority to obligate a competency evaluation based solely on age alone. What is required is reason to believe that the defendant isn't competent in what the trial court...
Well, you've got a 12-year-old standing there who's, 4 feet tall, and I know height is not a measure of competence, but, shouldn't that give pause to any trial court judge thinking, we better delve into this?
Your Honor, there was recognition and pause and extra procedures in this case recognizing his age. He was not treated like any adult defendant.
What were the
Well, he was an adult when the trial court started treating him as an adult. It already determined he was an adult.
Yes, Your Honor, but extra steps were taken to protect him in the sense that he had two vigorous attorneys representing him. His parents were both involved every step of the way. The plea agreement reflects that they all were part of the process. They discussed his options with him. There was a effort by defense counsel to have a psychological evaluation done for competency. That did not apparently present anything to counsel that caused him to think a formal evaluation was necessary. And in fact, after that, months after that evaluation, they came forward and said, defendant, both of his attorneys and both of his parents said affirmatively, he knows what he's doing. He understands the proceedings. He understands the charges against him. He understands the offer being put before him. He knows what he's doing.
What were the questions the trial judge put to Gingerich before accepting his plea? I mean, were there opportunities to explain his answers, or were they simply yes/no questions?
It was primarily yes and no questions, Your Honor. He did explain, again, went through every single one of his rights. And again, there was a detailed written statement from both, from Gingerich, from his two parents, and from his attorneys explaining that they had already done this, that they'd gone through every single part of this agreement with him.
Right,
They had
but
no reason to
so
believe-
the questions consisted of something like, you have the right to a trial by jury. Do you understand that? Gingerich says yes. Not, can you explain to me what a trial by jury is, right?
Correct, Your Honor. But again, the question is whether the trial judge had such information before it that it would have been obligated to independently order a competency evaluation, and in fact, he had every reason to believe that Gingerich was competent. Even the doctor's own report that suggests that juveniles between the age of 11 and 13, up to 1/3 of them may not be competent. Even if we accept that, that would still mean that 2/3, the majority of juveniles in the defendant's age range, are competent, and there's absolutely no reason to believe that the defendant wasn't part of that. But again, all of these questions are things that should be addressed at this stage in the proceedings through a post-conviction proceeding. And in fact, that would benefit the defendant in the fact that it would allow him to develop the record and the evidence that's just simply absent in this case. Instead of speculating about what might have been, about what he knew or didn't know, what his state of mind was at the time, and try to contradict what he told us, what the evidence says, current evidence says he did know, he would have the opportunity to present and develop an evidentiary record. And that is where this case belongs.
Ms. Sanchez, let me interrupt you for just a second. You have repeatedly referred to the presumption under the statute. Have the courts talked about a presumption under the statute, or is that your conclusion that the decisions that said that the juvenile bears the burden of proving best interest and safety, you derive that then constitutes a presumption from that
Just
language?
the fact that the statute states that if a juvenile over the age of 10 commits murder, they shall waive, juvenile court shall waive to the adult court unless it makes those two specific
If
findings.
it finds, and our Supreme Court has again said that shall not be a perfunctory proceeding, but is intended to protect the full panoply of rights. Were his rights, the full panoply of, his rights protected here? Are you confident that this is what other trial court judges should be doing?
Your Honor, I can't say that this is the best practice, but that isn't the question for the court.
No. Is this what other trial judges should be doing? Is this what we put out and we say, that's okay? May not be best practice, but that's okay. Because, he's signed off.
Again, Your Honor, the defendant had the opportunity to present evidence to challenge to meet his burden, but even if it was error not to grant the continuance, he still has the burden of showing that he was prejudiced by that error. And we don't have anything to record about what he would have shown that would have altered the outcome, no matter how much time and how many resources. The amicus brief points to the case of Devin Brooks, and that's an excellent example. With all the time and resources in the world, Devin Brooks was still transferred to adult court, and that decision was upheld by this court on appeal. As it stands now, the defendant has given up his right to bring the issues he presents in this direct appeal, and this court should dismiss this case. Thank you, Your Honor.
Thank you, ma'am. Ms. Foster, you have 5 minutes remaining.
Thank you, Your Honor. With regard to this case should be in post-conviction proceedings, I've never seen an attorney general's office so wed to waiver, and I can guarantee that if we would have brought a post-conviction proceeding without first trying to do a direct appeal with these issues in it, we would have waiver, even more than we have here. And that is simply because all of the evidence that you need to decide this case is known and available to us at this time, and for that reason...
What is it? Well, it may be known and available to you, but it is the case when you premise error on a failure to give a continuance, and I think that's your point, that you didn't have enough, your people didn't have enough time to prepare. Don't we normally require you to say that had you had that time, this is what you would have put before the trial judge, and that would have changed the game?
Yes, Your Honor.
And what is it that you've given us that should have been before the trial judge that would have been a game changer?
Number one, the fact that Paul was incompetent to stand trial. He never should have been participating.
Show me what says he was incompetent.
Your Honor, I believe that, as I said, Dr. Ross's report, I would also refer the court to Ms. Taylor's letter to the court, where she refers to the fact that she's been visiting with Paul and that he won't go participate in recreation because, and I quote, there's no one to play with. Where she says, Paul would share with me when his attorney came to visit, yet he never understood the purpose of the visit or anything they talked about. As an attorney, Ms. Taylor is an attorney, I began to feel extremely uncomfortable that our system of laws allows us to pretend a 12-year-old child has the competence to stand trial or effectively assist in their own defense. That was evidence in front of the trial court.
Okay, the evidence that Ms. Taylor advances is, it is her opinion that no 12-year-old should ever stand before.
No.
Well, that's what you just read to me, ma'am.
Your Honor, the evidence, no. What I read to you is he would share to me that he didn't know, when his attorneys came to visit, he never understood the purpose of their visit. That's specific to Paul.
Is it a case of first impression before us, an issue of first impression, whether it was abuse of discretion to fail to order a competency evaluation?
If the question is whether we should order a competency evaluation in the case of every person coming before a court that's 12 years and 2 months, yes. If it's a question of whether under Pate versus Robinson there was adequate evidence in this record that would cause a reasonable jurist to believe there was a question as to competency, no. Okay. With regard to this plea agreement that everybody got together on, let me tell you what preceded the state's magnanimity with regard to the plea agreement. First of all, Paul comes in, they give him 5 days. Can I have a continuance? No. Can I have a continuance? No, not once, but twice. Then, after the waiver is issued, his attorney moves to dismiss in adult court, saying the proceedings in the juvenile court were a denial of due process. You, adult court, have no jurisdiction. Denied. New counsel enters, re-raises the motion to dismiss. Again, asserting due process denial in the juvenile court, again saying the adult court has no jurisdiction, again denied. And then they ask for an interlocutory appeal. Can we please have review of what's gone on here? Can we get someone else to look at this? Denied. This is the landscape under which Paul's parents likely figured this is how the legal system works, enter into this agreement. Now, with regard to all these people signing the plea agreement, if that isn't evidence that they've got concerns about whether this kid knows what's going on, I don't know what is. Because I'll tell you what, as an adult, which is what he was when he entered, at least in the eyes of the law, when he entered that plea agreement, you go to prison with your mommy and daddy signing your plea and you got trouble. They had all these people sign the plea because even they believe there's a problem with this. With regard to Judge Brown, I can't let what you said pass. You said that he would stay in the juvenile system until he's 21. That's not true. Paul is in the juvenile system right now out of the good graces of the Indiana Department of Corrections. He actually should not be in the juvenile system because the court directed that he go to the adult system. The Indiana Department of Corrections is watching very carefully what this court does. They can't keep him until he's 21. He will likely go to an adult prison in the event that this court lets this situation stand. It is just through the good graces of the juvenile justice system, or of the Department of Corrections, that he's in the juvenile system now. When the state says that we don't know if there's a juvenile facility that would take him, he's in a juvenile facility. The state of Indiana has a juvenile facility where he is doing fabulously, where they are actually, and I know our juvenile justice system has been criticized recently, but they're doing a good job at the Pendleton Correctional Facility for juveniles. We have those facilities. He's in that facility. The evidence the judge got was false, and it was relied upon by the court. We can do better, and due process requires that we do better. Thank you.
Thank you, ma'am. Your time has expired. The court would caution counsel and the audience not to take anything from the questions that we've asked. We do so in order to stimulate our discussion and to answer those queries we may have otherwise had. We thank counsel for their presentations, both in writing and orally. We'll take this matter under advisement, and as is our wont, we will give you a timely response.